Now we've got the red stop recording, so I guess we are recording. I need all the witnesses if this doesn't record again. Hang up your phone, Gene. Go ahead.
Okay. Okay, this is what an ag lien looks like.
Let's identify the date for tonight, Gene. This is the 28th of May, 2011 webinar.
Do
Go
not
ahead,
forget
Gene.
to turn your recording on.
Yes, I did.
Make sure it's working.
And it's showing that it's recording.
Okay. Okay, we covered ag liens. We found out that they're treating you as an animal, as cattle, C-A-T-E-L, which means property, which is where the word cattle is derived from. You can determine that by word definitions, how they're using words. Now, an ag lien is under 9-102 is a lien, not a security interest. It gives you a lien interest, not a security interest. And on these mortgage loans, you want a lien interest, not a security interest. So you want to file an ag lien. And this is how they do ag liens. This is a form for an ag lien. Can everybody see it?
Let me close down the control panel. Okay.
It says, you put, what you want to do is you go to box 4 on the form, and it lists the collateral that you put on the form. In box 4, it says all farm products, inventory, accounts. You notice that when you go in, if you pull your B5 prospectus on your mortgage loans or on credit card accounts, it talks about accounts receivable. The accounts receivable are what's owed to the bank. The accounts payable are what the bank owes the depositor or the creditor. So what they do is they sell the accounts receivable. Now, accounts receivable on a credit card would be the credit card application that you fill out when you get a credit card. They take that application, they monetize it, and then they sell it. They call it securitization. They take that accounts receivable and they sell them. And they sell the paper, the chattel paper, which are your cash flow payments. When you buy something, you're making a credit card payment. Well, they take those credit card payments and they sell them to investors. They're called, promissory notes are called general intangibles. And you'll see that they're listed here. You have farm products, you have inventory, you have accounts receivable, you have documents, you have chattel paper, and general intangibles, now owned or hereafter acquired. Now they usually, when they do these, they usually have a list on the back. Some of these are only 1 page long. This particular one is only 1 page long. You put your name up here. See, this is AG Credit of California, a production credit association. This is in Stockton, California. We downloaded these from the Secretary of State's website. That's where you get those. I'm going to show you several of them. If you guys want copies of these,
We would love that.
Huh?
We would like copies. Show several.
I'll show you several. I have about 4 of them.
And our people can make screenshots.
You can see how these are, how a lien is put together. These are all UCC ones.
Some of our people, one of my main guys is not here for the screenshots. If you have the capability to do a screenshot, please do so and let me know. I haven't heard from him, so I don't know if he's on the call tonight.
Okay, you can see this is a more comprehensive list of collateral on this one. It says all farm products consisting of crops produced on trees, vines, and bushes, aquatic goods produced in agricultural operations, all supplies used or produced in debtors' farming operations, and all products thereof, and all replacements and additions thereto, now owned or hereafter acquired by the debtor. See, so you're doing, this is a futures market. Now owned or hereafter, so that means in the future. If you acquire property, then it automatically becomes a lien interest. Now or at any time hereafter located or growing or to be grown. See, that's past tense or future tense. To be grown is future tense. On the real property described below and wherever of the same may be located, and all such crops after they have been severed and removed from said real property, and all rights to payment pursuant to any federal or state programs relating thereto. Description of real property. See Exhibit A1 attached here to all terms of which are incorporated herein by this reference. All proceeds of any of the foregoing, including without limitation all rights to payment. You notice how they use the rights to payment. You have, when you have these mortgage loans, you have a right to payment, which shows up as a recoupment or set-off. That's why you got to have this lien in place.
How does that play into people that have lost their property?
You still have the right to payment.
Okay.
Remember, under 3-306, you have a possessionary right and or a property right in the instrument or its proceeds. That's under 3-306. You guys remember that? 3-306 and 3-305 gives you the right to recoupment. You remember that?
Yep.
You got to write this stuff down, because when you write it down, your eye takes a picture of it and puts the image on your brain. That's how you learn. I've been doing this for 50 years. I started this back in 1950, so actually that's 60 years. If you count 11, it's actually 61. I've been doing this for 61 years. And when you use your brain for 61 years reading stuff, it makes an impression on your mind. That's how you develop your memory. Remember, your memory is like a muscle. The more you use it, the more it develops. So you want to develop your memory. Well, this is how you do it. Now, I think this has a, see, they've got a file number down here. It says this financing statement is being filed in lieu of a continuation statement for the following previously filed financing statements, each of which remains effective. So these are other financing statements. Now this was filed in Merced, California, which is up by Sacramento. And you have this has another page to it. Now this is, so you put this down, if you're going to do it, this is an attachment to the UCC1. This is a blank sheet of paper. You notice that they stamp down there on the bottom, it says, "Attention, filing officer, please stamp and return with UCC1." So when you do your financing statement, you attach this to your financing statement. And there they give you the wording. This exhibit is attached to and made a part of the certain UCC financing statement naming Fraser Nut Farms, Inc. as debtor and Wells Fargo Bank National Association as secured party. The following is hereby incorporated into said UCC financing statement as the description of the collateral subject thereto. All farm products consisting of crops produced on trees, vines, and bushes. Now this is part of the Farm Crop Insurance Act of 1970, which is in Title VII. Title VII of the USCA, United States Code Annotated, contains all of your 50 statutes or your 50 codes, Titles 1 through 50. Well, Title VII is your agricultural code, and it contains all of your information regarding agricultural products and goods. So you want to list everything that's not on the statement. A lot of times the box is too small on the UCC1 to put everything on. So you got to put everything, you got to put some of it on an attachment. That's what this is. This is an attachment or an addendum that attaches to your UCC1, and you can list stuff on here. For instance, they got all farm products consisting of crops produced on trees, vines, and bushes, and aquatic goods produced in aquatic cultural operations. All supplies used or produced in debtors' farming operations, and all products thereof, and all replacements and additions thereto, now owned or hereafter acquired by the debtor. Now notice again, they do this in the future. These are futures. You want to put this down. They're using your credit. They use it presently. They use it from the past because we, and I use that word collectively, we are not using our credit. They're using it. That's why you never get a set-off or a recoupment, because they're using your credit. When they deny you credit, that means somebody's using your account besides yourself.
Explain that a little bit further for people that make their credit applications and they get denied.
A lot of times, and they've been denying me because there's some clown in there using my account. and I'm going to go after them. Maybe next week I have access to Westlaw, and on Westlaw they have a list of all of your DUNS numbers for all of your courts. All of your attorneys have DUNS number. And guess whose DUNS number I have a copy of? Who is the United States under?
Well, supposedly the Queen.
Yes. Guess who's got the Queen's DUNS number?
Oh, that's a wonderful one.
Yeah, I have a copy of the Queen's DUNS number. And in fact, I stayed up till 5 o'clock in the morning printing all this out. And guess who's under the Queen? The British Accreditation Registry, which is your bar association.
But how does that play in that recent case on John Anthony Hill?
Well, what happened is, her name is Wattenberg. She's a Canaanite from the House of Windsor. She's not from the Royal House of Tudor. I come from the Royal House of Tudor. I'm a direct descendant of Francis Tudor. Francis Tudor came from the marriage of Clay Tudor, which is the Order of the Red Rose, or the Rosicrucians, married Queen Elizabeth, the Order of the White Rose. So the Order of the White Rose married the Order of the Red Rose. And they had children. And their first child's name was called Francis Tudor, who you know as William Shakespeare. That's just a pen name that he wrote under. He's also known as Christopher Marlowe, Francis Bacon, Count Saint Germain. He's been alive for over 700 years. He discovered an elixir that stops the aging process. And he's been taking this for about the last 700 years. They started, the Francis Tudor was the one that started the Order of the Rosicrucians. And he is from the Royal House of Tudors. They have a TV program called The Tudors.
Been
I
watching.
haven't had a chance to watch it, but it's on TV.
Yeah, it's quite interesting.
The Royal House of Tudor are the direct lineal descendants. Now what happened is Francis Tudor was writing denunciatory pamphlets against his mother. That's called treason against the crown. And that's punishable by death. So Francis Tudor had a brother. She had the brother put to death because she thought it was he who was writing all these denunciatory pamphlets. And if you read some of Shakespeare's works, he was writing denunciatory pamphlets about his mother because he didn't like the way she was treating the people. And this is what happens when, now this isn't true of all people, but people get a little bit of power and they start abusing it, like they're doing now. This woman that is the queen now is a Canaanite, and she's from the Royal House of Windsor. Well, when they had the coronation, which is the stone of destiny, what she has to do is she swears an oath on the stone of destiny. They even used a fake stone. And this John Anthony Hill brought this out in a court case. I don't remember what court it was in. Was it in Chancery Court? Or
I think it was.
It was either in Chancery Court or in the Court of Common Pleas. And he brought this out during the trial, and the jury found him not guilty. They were trying to prosecute him criminally, just like they do over here. That's where all these barflies are doing. They want you to contract with them. These courts are courts of contract.
She's also a reptilian, some of our people say here.
Yeah, she is. She's a reptilian. She's a
Shapeshifter.
Shapeshifter, yeah. She changes. You can see the scales. George Bush is one from the Bush crime family. These people are a bunch of gangsters. And they're all part of these reptilians who take on human form. In the book of Jude, I think it's verse 3, it says they're twice dead, these Canaanites. They're the lineal descendants of Cain, and they're of the wicked one. Well, you notice on this attachment to this UCC1 that they have a description of real property. You want to put your land description, and preferably the metes and boundaries. You want to put the metes and boundaries description on here. The reason being, metes and bounds is a land description, not a property description. They call it a real property description on your, when they do a financing statement, but that's not what it is. It's not real property. Land is land, not property. Everybody refers to it as real property, but it's called land. And the metes and bounds is your common law land description of your land, and it's measured in distance and direction, as opposed to township, range number, lot number, section number. They had them divided up into, when Thomas Jefferson started this land registration, called the Land Registration Act of 1785. They started registering property. Well, this is a continuation of that. That's how the American people have got registration fever. They register their guns, they register their property, they register their land, they register their children, and when you do that, you transfer ownership of your property. You make your kids wards of the state, and you become a ward of the state.
Have you got another one of those agricultural liens to put up on the screen, Gene?
Sure, I got a bunch of them.
If you could just show.
Is there any questions about this?
I haven't had any questions on that. We have some questions on your security.
Notice okay. Notice it says all rights to payment with respect to any insurance. All these mortgage loans are insured against default. When they go into default, the insurance pays off the loan. And also on your title insurance. Here's another issue. They have what they call errors and omissions on the insurance policy, on your title insurance. Okay, you notice it says in there, I am lawfully sized, the borrower covenants, that he is lawfully sized of the below described property. lawfully sized, and hereby transfers all right, title, and interest in the below described property to the lender. That's when you have abandoned all right, title, and interest.
But this stuff is all done behind your back.
Yes. They do this behind your back. You abandon your property at closing. That's why you should walk out with the mortgage, which is the deed of trust. You'll remember last week we covered the fact that when they do these loans, they don't transfer the loan documents. That is, they don't transfer the note, and they don't transfer the deed of trust.
And it has to be together. And they never
have
do.
to be together. They're inseparable. The note represents the obligation that's owed on the mortgage, which is the deed of trust. Well, if they don't transfer the mortgage to the REMIC, and they don't transfer the note to the REMIC, there is no loan. The loan is in default at closing. That's why the requirement that they file an election to treat the REMIC as a real estate investment trust. And it says that in 856 C, small c, parentheses number 1 of Title 26. So I'll repeat that. Title 26, Section 856 C1 says the taxpayer, and the REMIC is referred to as a taxpayer, is required to make an election. Now, how do they make this election? They file a statement with a tax return to treat the REMIC as a real estate investment trust. If they don't do that, then they have to pay taxes on their taxable income, their capital gains. And if you read some of these B5 prospectuses, and I've got a bunch of them here, we can go in there and look at some of them if you want to. I'll show you how much. You've got trillions of dollars in there in capital.
Right, that they're not declaring.
Yet they're not paying the taxes on. So what they're doing when they foreclose on your property, what they're doing is they're doing a forfeiture. They're forfeiting your property because it was in default at closing because the taxes weren't paid on it. And the taxes weren't paid on it because they didn't transfer the loan documents to the REMIC to treat the REMIC as a real estate investment trust. That's number 1. Number 2 is they have to file a statement to treat the property as foreclosure property before they can foreclose on it. And the reason is because they're doing a disposition of property which is related to income. These funds that they are transferring represent income, or capital income, or capital gain, which is why Section 11 of Title 26 says there's a 35% income tax imposed upon capital or income over $210 million. They start out at a smaller percent, and it goes up to 35% maximum.
What was that citing again?
What was what?
What was that one you were just talking about? Something 11.
It's Section 11 of Title 26. Do you want to go in there? You want to see it?
No, I just wanted to complete the notes that we're all taking. So
Okay,
they have a 35% mandatory capital gain taxes.
Yeah, these are mandatory taxes. that they have to pay.
Up to what?
Up to $210 million. I'm going to show you they have a they have a chart that shows the it shows what they're taxing and how much. They have a schedule in there. And I'm going to show you the schedule. Notice it's subtitle A, income taxes. Okay, here's the taxes imposed. Okay, this is section 11. Can everybody see this?
You want me to read it?
Yeah.
Where do I start? Corporations in general. A tax is hereby imposed for each taxable year on the taxable income of every corporation. Amount of tax. The amount of the tax imposed by subsection A shall be the sum of 50% of so much of the taxable income as does not exceed $50,000, 25% of so much of the taxable income and exceeds $50,000 but does not exceed $75,000. C, 34% of the taxable income as exceeds $75,000 but does not exceed $10,000. And D, 35% of so much of the taxable income as exceeds $10 million.
Okay, the other one was $10 million. You said $10,000.
Oh, I'm sorry. C was $10 million. And 35% over $10 million.
Yeah. Okay, that goes if see, they have a grace period, which is only invoked if the loan documents, the note and the deed of trust are transferred. They have a grace period in which to take this election or to file this tax return. But if they don't transfer the deed of trust and the promissory note, then the grace period is revoked. They don't have a grace period. So this tax goes up to 100%. So it's not 35% of so much of the taxable income. It's 100%. So what's 100% of 10 million? It's $10 million. So they have to pay a $10 million tax. How would you like to get a tax bill like that?
Well, that's what we all need to start bringing to the forefront against these mortgage companies.
Okay, but this is what they're doing. This is why this issue is a tax issue. And if they don't pay the tax, or if they commit a violation, there's a $50,000 penalty.
That's 856, isn't it?
Yeah, it's in 856E5. There's a $50,000 penalty for each violation. Well, the first violation is they didn't take the election to treat the REMIC as a real estate investment trust. That's a $50,000 penalty. The second violation is they didn't file a statement to treat the property as foreclosure property before they foreclosed on it. The reason being, that's what they do. What do? When they foreclose on your property, they file a 1099-C, which is a debt cancellation. So cancellation of debt is forgiveness of indebtedness. It's in publication 550. If you go read publication 550, it tells you how they do that. When they forgive indebtedness, the person that they forgive it to it becomes taxable income. That's why this is a tax issue. And when they do a forfeiture, that means that they're charging you with the tax because you're not making them pay it.
Okay.
You're the donor. What does the donor do? The donor has the power of appointment under the Power of Appointment Act of 1951. You guys remember this?
So we can appoint them to pay it, and they have to.
They have to pay it. They're the donee.
Do we have to file a special paper on that?
Well, this is where everybody's filing the wrong returns. You have on the estate side, you have a $5 million unified tax credit or exclusion. It was $3,500,000. But as of 2010, you have a $5 million tax credit or unified tax credit, tax exclusion or unified tax credit. It went up to $5 million. It was $3,500,000 in 2010. Then they raised it to $5 million in 2011. So you now have, but you don't have a carryover basis now.
What do you mean?
Remember, that's an alternate valuation on a carryover basis. This is what they're
Explain that in
taxing.
English.
Well, a carryover basis means the value of your estate at the time that the decedent died or at the time of any transfer, distribution, or termination of your interest in property, or a general skipping transfer. A skipping transfer is when property is transferred or money is transferred from a trust fund. When they do a foreclosure, they're doing a taxable termination. Now, a taxable termination, the trustee has to pay the tax on a taxable termination. Now, where does it say that? I'm going to show you where that, you need to write this down. Write this down. This is important. I don't know if this thing's going to allow me to, yeah, okay, here it is. Liability for tax. This tells you who's liable for the tax. Write this down. This is important. This is on gift taxes. This is who's liable for the tax. Read 1. Read the personal liability. Read what it says. Maria?
All right. Taxable distributions, number 1. In the case of a taxable distribution, the tax imposed by Section 2601 shall be paid by the transferee. Taxable termination. In the case of a taxable termination or a direct skip from a trust, the tax shall be paid by the trustee. Direct skip. In the case of a direct skip other than a direct skip from a trust, the tax shall be paid by the transferor.
Okay, write this down. Let me know when you got all this stuff written down.
Explain some of that. Explain the transferor, the transfer.
Okay, let's start with the first one. It says personal liability, taxable distribution. That's paid by the transferee. The transferee is the recipient. You notice that when you have a 1099-A, a 1099-C, all these 1099s have a payor and a recipient. The payor is the transferor, and the recipient is the transferee, or the person that receives the property. If it's money, then it's the transferee. In this case, you're dealing with promissory notes, which is money. and you're dealing with a mortgage deed or a deed of trust, which is a mortgage. Now, when you transfer that, whoever you transfer it to, you transferred it to the servicing company at closing. So you're the transferor. The person that's doing the transfer is the transferor. The person that receives the transfer is the transferee. That's the difference between the two.
So that means they owe the tax.
That means they own the tax if they're the transferee and they're the trustee. Remember, you're the trustor. You're the trustor, grantor, settler.
Okay. So how about the trustee?
Well, who's the trustee? All deeds, mortgage deeds, have a trustee listed. And the trustee is the one that has to pay the tax on a taxable termination.
That's why you appoint the mortgage company to be the trustee.
Yes. And so we're going to go to 26. You need to write this down. This defines each one of these terms, and we're going to look at these definitions. Okay. What does that say a taxable termination is?
Taxable termination general rule. Taxable termination means the termination by death, lapse of time, release of power, or otherwise of an interest in property held in trust unless immediately after such termination a non-skip person has an interest in such property. Or B, at no time after such termination may a distribution, including distributions on termination, be made from such trust to a skip person.
So when they foreclose on your property, isn't that a taxable termination? Aren't they releasing your interest in the property in a trust?
Yeah.
And what is the trust? Isn't the deed of trust a trust?
Yes.
And isn't your property description in the deed of trust?
Right.
So they're releasing your interest in the deed of trust by terminating it. That's called a taxable termination. And they're making you pay the tax. You're not the trustee. If you people don't wake up, you're going to be sitting in a field wondering what struck you. This is no joke. Nobody in the Patriot movement understands what I'm teaching, what this is. That's why I'm going over this.
Okay, so
this is important stuff. So write it down. So you have a taxable termination, which is the release by death, lapse of time, release of power, or otherwise. That means any way that they do it. By foreclosure. Foreclosure is a release of power.
Right, but they, according to 2603, or let me see, they can't do a foreclosure if they have not declared the property foreclosure property.
That's right. So it's a $50,000 penalty on them. But who makes them pay it? You show me anybody that's bringing this up outside of me.
Well, people are looking for a process and a recipe to do that. Not that they don't want to do it; they don't know how to do it.
Okay, well, we're laying
That's
the
what we're
foundation.
here for.
But you got to learn you got to understand what you're doing before you go out there and do it. That's why you don't win in court, because you don't know what you're doing. You got to know what you're doing. Okay, it says immediately after such termination, a non-skip person has an interest in such property.
That would be the servicing company or the mortgage company, wouldn't it?
Yes. A skip person, we're going to look at that. A skip person is a trust fund. A non-skip person is a non-trust. We're going to look at that in a minute. But we're going to go through this first. Okay, go ahead and finish reading this.
Where am I reading?
Well, A. Go start at A.
A. Again, taxable termination. For purposes of this chapter, the term taxable termination means a termination by death, lapse of time, release of power, or otherwise of an interest in property held in a trust unless A. Immediately after such termination, a non-skip person has an interest in such property, or B. At no time after such termination may a distribution, including distributions or on termination, be made from such trust to a skip person. Number 2, certain partial terminations treated as taxable. If upon the termination of an interest in property held in trust by reason of the death of a lineal decedent of the transferor, a specified portion of the trust assets are distributed to one or more skip persons or one or more trusts for the exclusive benefit of such persons, such termination shall constitute a taxable termination with respect to such portion of the trust property. You want me to go further?
Yeah, now read the B.
Taxable distribution. For purpose of this chapter, taxable distribution means any distribution from a trust to a skip person other than a taxable termination or a direct skip. C, a direct skip. For purposes of this chapter, the term direct skip means transfer subject to a tax imposed by Chapter 11 or 12 of an interest in property to a skip person.
So Chapter 11 is your gift tax, and Chapter 12 is your estate tax. So of an interest in property to a skip person. Remember, a skip, we're going to show you that. A skip person is a trust fund. This all involves trust funds. Remember I told you have to understand tax law, trust law, commercial law, and accounting in order to understand all this. Because all these subjects are related and they interchange with each other. Go read number 2.
Number 2. Which 2? Look through rules not to apply?
Yeah.
Solely for purposes of determining whether any transfer to a trust is a direct skip, the rules of Section 2651, small f, number 2, shall not apply.
Okay, so you have 3 types of taxes. You have a taxable termination, you have a taxable distribution, and a direct or indirect skip. Okay, now we're going to go on we're going to look at what a skip person is and a non-skip person. Okay, go ahead and read this.
A skip person means a natural person assigned to a generation which is 2 or more generations below the generation assignment of the transferor, or a trust, if all interests in such trusts are held by skip persons, or B, if there is no person holding an interest in a trust, and at no time after such transfer may a distribution, including distributions on termination, be made from such trust to a non-skip person. Non-skip person means any person who is not a skip person.
So a non-skip person is a skip person is a natural person or a trust. You need to write this down. 2613. E, a skip person means a natural person, number 1, or number 2, a trust. So a skip person is a natural person and a trust, and or a trust. So A non-skip person is any person who is not a skip person, which means who is not a natural person or is not a trust. So anything that's not a trust or a natural person is a non-skip person. Write this down so that you can remember this, because these explain what they're doing. Okay, here's the, go ahead and read this. This tells you these are called generation skipping transfers.
Okay.
2611.
For purposes, generation skipping transfer means a taxable distribution, or 2, a taxable termination, and 3, a direct skip.
So these are all classified as generation skipping transfers. Okay, so they're telling you certain transfers are excluded from a generation skipping transfer. Go ahead and read that.
Excluded. Does not include, generation skipping transfer does not include any transfer which, if made inter vivos by an individual, would not be treated as a taxable gift by reason of Section 2503 small a, relating to exclusion of certain transfers for education or medical expenses. And 2, any transfer to the extent, A, the property transferred was subject to a prior tax imposed under this chapter, B, the transferee in the prior transfer was assigned to the same generation as, or a lower generation than, the generation assignment of the transferee in this transfer, and C, such transfers do not have the effect of avoiding tax under this chapter with respect to any transfer.
So you've got 3 types of taxes. You've got a taxable distribution, a taxable termination, and a direct skip. They're doing all 3 of these. A direct skip is a transfer from a trust fund. A taxable termination is when they do a foreclosure. But remember, they can't do a taxable termination, which is a foreclosure, unless they file a statement with a tax return electing to treat the property as foreclosure property. They can't do that. It says that in 856E5.
So what's the other skip then on that? What would be a direct skip?
Well, a direct skip is a, remember what we read that in 2613. A direct skip is a transfer from a trust. Well, aren't they transferring the property from the deed of trust to the REMIC? So that's a direct skip. You're transferring the deed of trust to a trust fund, or you're transferring property from the deed of trust to, and that's what, when they do a foreclosure, they're doing a direct skip.
Okay.
Or a taxable termination. You have a taxable termination. They're terminating your interest in the property.
Okay.
That's why securitization is illegal. They're taking, they're transferring they're taking the property out of the deed of trust and transferring it to a REMIC.
Okay, but they never do that. So that's where they do wrong, and we can go back in and retake our interest.
Yeah, you can get your interest back.
And that doesn't matter how long ago, because they have to take, even if they foreclose on the property, the new buyer still takes that property, subject to your defenses of set-off and recoupment.
Yes. You have a right to set off and recoupment. You remember what that was in? That was in 1413 of 111-201, July 21st, 2010. That's the Dodd-Frank reform. It's called the Dodd-Frank Wall Street Reform Act, or the Consumer Protection Act. Most people don't even, I haven't met anybody that's even heard of this.
Dodd-Frank what?
Here it is.
Say it again.
Well, let me close this out. We'll go up here to
Reform Act. Isn't that what you said?
there it is. Can everybody see that?
Reform Act.
It's called the Dodd-Frank Wall Street Reform and Consumer Protection Act. Can everybody read that? I got this off of the internet. You can download this off the internet.
Okay.
If you go down here to okay, here's what's going on. I'm going to spell this out for you. This is the credit. This is called bank securitization. This talks about this. This is section 1941 of this act.
Okay, so what about these banks, these local banks that say they don't have to transfer into a REMIC, they're still holding the paper? Does all this apply to them too?
Then they have to pay the tax on it. You have to transfer the papers within a time frame after you acquire it, within 90 days. They have to transfer it or they have to pay the tax. They don't have to transfer it, no, but then they don't get the unified tax credit. You see why they have to transfer it?
Okay, so they don't have any leeway to choose what they want to do. If they choose that they don't want to transfer it, they have to pay that tax.
Right, and what they're doing is making you pay it by forfeiting the property.
But isn't that tax the mortgage?
Yes. What's your first clue?
Deed of trust?
I want you to read this. This is very, very, very important.
Read what?
Read this.
The term federal...
Definitions. See where it says definitions? Start up here. Credit risk retention.
Okay.
They have to retain 5%. The lender or the servicing company has to retain 5% of the credit risk.
Okay.
But only if it's a qualified mortgage under 860G of Title 26.
Okay.
And it's not a qualified mortgage unless the deed of trust and the note are transferred to the REMIC.
Okay, Section 15G, credit risk retention. Definitions. Federal banking agencies means the Office of the Comptroller of the Currency, the Board of Governors of the Federal Reserve System, and the Federal Deposit Insurance Corporation. The term insured depository institution has the same meaning as in Section 3C of the Federal Deposit Insurance Act, 12 U.S.C. 1813C. The term securities means...
No. What does that say?
The term securitizer means a an issuer of an asset-backed security, or B, a person who organizes and initiates an asset-backed security transaction by selling or transferring assets either directly or indirectly, including through an affiliate to the issuer. And 4, the term originator means a person who, A, through the extension of credit or otherwise, creates a financial asset that collateralizes an asset-backed security, and B, sells an asset directly or indirectly to a securitizer. And then big subsection B, regulations required. You want me to read that?
Yes.
Not later than 270 days after the date of enactment of this section, the federal banking agencies and the Commission shall jointly prescribe regulations to require any securitizer to retain an economic interest in a portion of the credit risk for any asset that the securitizer, through the issuance of an asset-backed security, transfers, sells, or conveys to a third party. Number 2, residential mortgages. Not later than 270 days after the date of the enactment of this section, the federal banking agencies, the Commission, the Secretary of Housing and Urban Development, and the Federal Housing Finance Agency shall jointly prescribe regulations to require any securitizer to retain an economic interest in a portion of the credit risk for any residential mortgage asset that the securitizer, through the issuance of an asset-backed security, transfers, sells, or conveys to a third party. Standards. The regulations prescribed under subsection B, I can't read that through, something Roman numeral 2. A, prohibit a securitizer from directly or indirectly hedging or otherwise transferring the credit risk that the securitizer is required to retain with respect to an asset. B, require a securitizer to retain.
So a securitizer means an issue of an asset-backed security. Or B, a person who organizes and initiates an asset-backed security transaction by selling or transferring assets either directly or indirectly, including through an affiliate to the issuer. The term originator means a person who, through the extension of credit or otherwise, creates a financial asset. Okay, so you created a security which is defined in 8-102 as a financial asset. You remember that? We looked at that a couple classes ago.
Okay. It's all in our previous webinars.
8-102 defines a security as a financial asset. Well, who transferred the financial asset to the servicing company? You did.
Well, without knowledge.
Well, you gave it. You did it knowingly. You gave the loan documents to them, didn't you?
Right.
And then they took it and they act as a securitizer. They took the financial asset and they sold it to the REMI, supposedly. At least this is what the B5 says.
Would a bill from a state tax be a taxable termination?
Is what?
Would a bill from a state tax be a taxable termination?
Yes, if they foreclosed on you, yes. If it was for a foreclosure, yes. If they're terminating your interest in the property, that's a taxable transfer.
So when you record a deed, is that a taxable termination?
Yes.
Okay.
What are you doing? Remember we looked at insinuation under the civil law? You remember that?
Right.
Okay, what did it say? You remember what it said?
No, I don't.
Okay, we're going to revisit that.
Okay, we have a question on the board here, Jean. The Dodd-Frank Act also changes the QWR response time. What is QWR? I have no idea. From 30 days.
Qualified written request.
Okay. qualified written requests from 30 days to 5 days and settlements within 30 days instead of 60 days. Okay, some people are saying they're losing the sound from tonight. Tom, are you getting all the sound? They're saying you and I are going mute, Gene. I don't know why.
We're losing the sound?
I don't know.
Can you hear me? Can you hear me now?
I hear you fine. Okay, Rick is saying he hears everybody fine. Okay. Tom, are you hearing everybody fine? Give me a Skype message if you can. Okay, Tom says that we have other people saying they're hearing us fine, and so does Tom. All right.
What does this say?
Insinuation civil law. The transcription of an act on the public registers, like our recording of deeds, it was not necessary, let me close down this screen, in any other alienation, like our recording of deeds, it was not necessary in any other alienation, but that appropriated to the purpose of donation. Instructions 272, I think that's what that says. That's
Poth.
Poth.
You know who Poth was?
No.
He wrote in Rome. He was a Roman scholar that taught that institutes means institutes of law.
Okay. So that would be Institutes 272. Poth, but that appropriated to the purpose of donation.
Okay, what does that mean when you donate something?
Well,
who's liable for the tax on a donation?
The person that receives it?
Well, the donor is. Technically, the donor is under 2502.
Okay.
Okay, what is it? There's key words here. Transcription, alienation, and donation are the key words in here.
Okay.
Okay, what does alienation mean?
To alienate, to divest an interest.
Yes. It means to transfer right, title, and interest.
Okay.
Inalienable means what? They can't be transferred, right?
Right.
Well, this is just the opposite of that. Alienation means they can be transferred.
Okay.
So just substitute the words. It was not. I'm going to tell you what this really says. The writing of an act on the public register, like our recording of deeds, it was not necessary in the other transfer of right, title, and interest, but to our recording of deeds. It was not necessary in any other transfer of title and interest in property, but that appropriated to the purpose of donation. Now do you understand it? What you're doing is transferring right, title, and interest in the property.
Right, and they're saying only when you transfer or donate an interest in property, it has to be recorded.
Yes.
And nowhere else does it have to be recorded on anything else.
Yeah.
Okay.
Okay, now you know why you don't own the property. You transferred. Alienation means transfer of right, title, and interest.
Okay, so should everybody be doing these agricultural liens and learning how to get them done quickly here on all their properties?
That's an affirmative.
And also to protect. Can you go nunc-pro-tunc on any of that?
Yes.
So if you go nunc-pro-tunc back to the day before you took out the loan, then that sets up the summary judgment for you to get your property back, or you to take them to task for not paying the taxes.
Yes, you can make them liable for the tax. Remember, you have as the donor, The donor has the power of appointment.
Okay.
So you have the right to appoint the donee. You can make him pay the tax by appointment, but you have to exercise it.
Okay. All right, so that's pretty clear on the ag liens. We want to take a little bit of time tonight. We have like 4 questions on the board that haven't been answered. The comments from last week is on your security agreement. We didn't get it out this week. And so we're going to try and get it out this week. Also, Gene, the 706 and 709 form. If we can spend a little bit of time on that and move on next week with stronger emphasis on it. Can we rescind our signature on a mortgage after 3 years for common law fraud or because of the statute of frauds?
Yeah, you can do that in 226.23 of TILA. They have a form for doing that.
Okay, so you're going to go into TILA and go into form under 26.3.
Okay, let me close this out and I'll show you how to do that, how you look this up. Okay, you got to type in here electronic code of regulations.
Okay, we've got some questions on W-9s coming up on the board here. If your treasurer of your county or your town says they're tax exempt on the W-9, you have to ask for they went to the treasurer, so you just need to turn it in to IRS, because on the bottom of the form it says they have to fill it out. What do you do when they say that they're tax exempt?
Who says they're tax exempt?
The township treasurer.
They're not tax exempt.
Well,
why are they tax exempt?
One person is saying, I asked the treasurer, and she said if you send it to us, she would return it with a notice from the town that the town is tax exempt.
What kind of tax is it?
She was for that sets up the W-9. Is that what you're asking?
No, the W-9 is your taxpayer identification number.
Right. But the treasurer is saying they don't have to fill that out. I've not heard that yet. I've heard it's a $50 fine when they don't do it.
If they have a taxpayer identification number, they have to fill it out.
And what if they come back and say, no, we're tax exempt? I would say put that in writing. They never will.
Well, tell them what's their grounds for being tax exempt.
I would say, I conditionally accept your verbal offer to deny filling out the W-9 upon
proof that you're exempted from that requirement.
Upon proof of claim of, that you are exempted from that requirement.
Okay, what does this say here?
Rights of rescission. 230, I can't read it, 224.33.
No, it's 226.23.
226.23, right of incision. A consumer's right to rescind in a credit transaction in which a security interest is or will be retained or acquired in a consumer principal's dwelling. Each consumer whose ownership interest is or will be subject to the security interest shall have the right to rescind the transaction except for transactions described in paragraph F of this section. For purposes of this section, the addition to the existing obligation of a security interest in a consumer's principal dwelling is a transaction. The right of rescission applies only to the addition of the security interest and not the existing obligation. The creditor shall deliver the notice required by paragraph B of this section, but need not deliver new material disclosures. Delivery of the required notice shall begin with the rescission period.
So you have the right.
Okay. Is there a time limit on that?
No. Okay, what does this say? What does that say right there?
Right where? Point F. Exempt transactions. The right to rescind does not apply to the following: a residential mortgage transaction, a refinancing or consolidation by the same creditor of an extension of credit already secured by the consumer's principal dwelling. The right of rescission shall apply, however, to the extent the new amount financed exceeds the unpaid principal balance, any earned unpaid balance charges on the existing debt, and amounts attributed solely to the costs of the refinancing or consolidation. Now,
Okay,
how come does it say a residential mortgage is exempt?
Okay, why are residential mortgage transactions exempt from TILA? I want you to tell me.
From TILA?
What is TILA? Truth in Lending Act, isn't it?
Right. That's why they can lie through the deed of trust and do everything behind your back without you knowing it.
Okay, what is TILA, what does Truth in Lending cover? What kind of transactions?
Mortgage transactions, credit transactions.
Huh?
Credit transactions.
Okay, can you loan credit on a mortgage transaction?
Can you loan credit?
Yes.
No.
Well, that's why it says you can't, this doesn't apply. Okay, now notice here, read this. What does H say?
Special rules for foreclosures. Right to rescind. After the initiation of foreclosure on the consumer's principal dwelling that secures the credit obligation, the consumer shall have the right to rescind the transaction if A1. A mortgage broker for that should have been included in the finance charge was not included, or 2, little 2, II. The creditor did not provide the properly completed appropriate model from an appendix H of this part, or a substantially similar notice of rescission. Tolerance for disclosures. Number 2, regular 2. After the initiation of foreclosure on the consumer's principal dwelling that secures the credit obligation, the finance charge and other disclosures affected by the finance charge, such as the amount financed and the annual percentage rate, shall be considered accurate for purposes of the section if the disclosed finance charge is understated by no more than $35 or is greater than the amount required to be disclosed.
So this has got two. You'll notice it says it doesn't apply to residential mortgage transactions. But then down in H it says special rules for foreclosure. When it goes in, when the foreclosure is initiated, you have the right to rescind. Why do you have the right to rescind? Because they can't loan credit. What does Title 12, Section 24, Paragraph 7 say? Banks can only, powers of national banking associations. They can only loan money. They can't loan credit. So you have a right to rescind the transaction.
So that's a wonderful conditional acceptance statement. I conditionally accept your offer to foreclose my interest upon proof of claim that you have a right to loan credit.
Yeah.
Okay.
Look at this thing. Thing's going crazy. Look at it moving by itself.
Yeah. What was in the attorney record, Patricia, not the 80,000, it was violations that the attorneys are doing when they're not paying the taxes. Go read it again. Okay, so since TILA doesn't apply to a mortgage, the 3-year restriction on rescission applies only
when it goes into foreclosure. What did it say?
When it goes
into foreclosure, you have the right to rescind.
Okay.
That's the reason, because they cannot loan credit. Nobody does that. We did it.
Okay, if these attorneys and judges don't respond to the attorney letter, how long do you wait before you submit the tax forms? You wait 10 days and that's it.
Yes.
Okay, the courts are getting their W-9s back, so that treasurer is in a lot of hot water if they don't give it to you.
Okay, remember it says the form to rescind is in the appendix?
Okay, the form to rescind is in the appendix, so you want to go look it up on that, citing up about 20.
Here's the
226, 22, 23.
appendix H. We got to find appendix H here.
Appendix H and 226 on TILA. What is the act that banks can't lend money?
I'll go to it here in a minute.
Okay. Why are you asking these questions? That's the Banking Act of 1929.
I gotta find the appendix here. Okay, here's the form right here. Here's the rescission form.
Okay. Can you rotate that, Gene? It's not going to let you rotate.
Usually it has a button for doing that.
Oh, get down on your blue square on your PDF. I think it's over some more. Over at the end.
Down this way?
No, the other way. Over, a little bit more, a little bit. There you go. That should be the rotate button. I'm not sure. Right click it and see if that'll rotate.
Let's see.
It might not.
Usually it's up here.
I know it is, but it's not giving you under the view. It should have view, but it's not doing it. PDFs are a little bit different than regular docs. Should be under view, but it's not there. Look under your toolbars. See if it's there. It's not rotating. Anyway, we got a side view of it, so they'll know where to look in Appendix H under TILA 226.
But this is the form that you used to Oop.
Yeah, it's not going to do. Okay, we've got a screenshot of it that way, so people will just have to figure it out. Okay, let's move on to, we've got one question, one criminal question on the board tonight when we're all done, because this isn't really applying to anything tonight, but I want to bring it forward before we break. Last week you talked about your power of appointment form that you had that you did. Is that going to be an attachment for this week's call? And along with that is the killer letter that you said you were developing for foreclosures. Have you got that finished yet?
No, I'm still working on that.
Okay, so we're still working on that one. So we have the power of appointment form and your security agreement format. Will those be attachments to this week's class?
Yes, we can.
Okay. You'll have to get them to me so they can be attached. Okay, let's see if we can move on. We don't have very much time left to get into 709 and 706. Okay, somebody here wants to do one-on-one with you about their mortgage foreclosure. Send me an email.
Okay.
Send Gene an email and let him respond to his schedule for you.
Okay, this is the 709, which is a gift tax return.
Okay. Jerry, his email is on the information letter I sent you. Okay.
Okay, here's your unified credit. It says see instructions. Okay, you go down here to 7, and it's built into your form. The tax credit is.
Form.
You guys are not using your
It should be 5 million, shouldn't it?
Well, that's on the gift side.
Okay, which form is this? The 706?
Yeah, this is the
709 form?
yeah, this is 709.
Okay, so on line 7, we put in 5 million, or it's already on the form when you order it?
Well, this is your unified tax credit on gifts. The 5 million is on the estate side.
Okay.
This is on the gift side.
So what do you fill out in each one of these sections up here? What is the important boxes that have to be filled in?
Okay, this is the form.
Yeah.
Okay, the donor. You put your name up here.
And that's upper and lowercase?
Yeah, you put the uppercase, first name and middle initial. Then you put your donor's last name.
Okay.
Donor's social security number.
And that's with the dashes?
With the dashes. That's your taxpayer identification number.
Okay.
Then you put your address here.
Okay.
Street address. Legal residence, domicile. What's your city?
What's the difference between address and legal residence?
Legal residence is your domicile, where you're domiciled, or resident.
So then you don't put anything in the address?
Well, you put your address, which is the number, the street.
One is the number, and the other one is the street, right?
Right.
Okay.
Then you put your city, state, and zip code here, and your citizenship here.
Okay, so what is citizenship?
Okay, this is very important.
Wouldn't that be American national?
Here's what before we go into this, I want to show you guys something. I just filled one of these out.
W8BEN.
See this one here? This is the W8BEN you want to fill out. What does this say here?
Certificate of foreign status.
Okay, when you fill out these returns, you want to put, see this box here? What does that say?
Transient foreigner.
That puts you under the Foreign Sovereign Immunities Act.
Okay.
And you can put down here what capacity in which acting. Put national of the United States.
Okay. Anything else that we put on there?
Well, you want to be sure you use this one. You'll notice that these, you see, remember where this is?
Transient, yes, foreigner.
Okay, you want to save this. Save this to the desktop.
Okay.
Okay, I'm going to show you guys something.
There's nothing there on that one.
You don't have that in there, do you?
No. So everybody's been filling out the wrong W8BEN form.
Yes.
They've been filling out the BEN1 form, and we want to fill out the W8BEN with no one. The other one didn't have a 1 on it.
Okay, here's another W8BEN.
My gosh, how many forms they got for it? It's not on that one either.
But see, it's not there, is it?
No, because that's for a foreign status of a beneficial owner, where the other one was certificate of foreign status non-resident alien.
Yeah.
Did you catch that subtly, class members? Make sure you're filling out the right W8BEN form. Now, how does that play with people that say they have military benefits? If a member of their family, a spouse or somebody, or their husband has fulfilled that insurance contract.
See, this is for United States citizens. And what are United States citizens under the War Powers Act? They're enemies of the United States.
So if we fill out the W8BEN for the national of the U.S. capacity, how does that change our capacity on everything?
Makes you under the Foreign Sovereigns Immunities Act.
So if you held a passport, a regular passport, and you fill out this form and you notify the passport office, don't they have to give you the red cover passport?
Yeah, because you're a foreigner.
That's what I thought.
This brings you under the Foreign Sovereign Immunities Act. Now, you remember the difference?
Okay. As a foreigner, you should not have to go through that TSA shit either. Right?
Yes.
It's making full circle there, guy. Okay, this one is a status of non-resident alien. That's what makes it different, because then it has the transient foreigner. So what do you put as a permanent address? Nothing, because you're transient?
Put down your box number, or put the one that David Clarence puts.
Right.
That puts you out of the country.
Right.
The territorial. What is it? What does he use? He uses the.
Well, you put your house numbers behind your street name, not the other way around. And then you don't even need to say the state. You just need to say near wherever the zip code is, indicating you're not in that zip capacity.
Because remember, the states are
federal zones.
Federal zones, yeah, under the Buck Act.
Right. Okay, do we have to worry about part 2 or part 3?
But you want to fill this out first.
Okay, so how do you do number 3 there, part number 2? Which one do you mark?
Well, you don't claim of tax treaty. You're not claiming a tax treaty, so you don't fill that out.
So you don't fill out number 2.
Yeah, it says
About
claim.
Number 3.
It says claim of tax treaty benefits.
Okay, but we're not doing that. How about national?
You don't fill that out. Let's go up. Let's go
How
up here
about
at the
part
top.
3? Principal contracts or contacts or some darn thing.
What does this say? It says, do not use this form for a U.S. citizen or other U.S. person, including a resident alien individual. Instead, use a W-9. What does it say over here?
Okay, but we don't have to do that. So we're not U.S. citizens, we're not U.S. persons, and we're not resident aliens. So it don't apply. Right? We're not a foreign government.
So you put part 1 here. You put name. Put your name down here. Put
Okay.
Gene, like Gene Keating, family of Gene Blaine, family of Keating.
Okay, that's in upper and lower case, right?
Here's how you would type it up.
Okay. Okay.
Notice it says here, country of incorporation or organization, human being. So you put transient foreigner. You click this box right there.
Yeah. So you put NA, human being. Okay.
Permanent address.
Okay.
Okay, your country is the United States of America. Okay, when you put your state in here, type it in lowercase letters because it's a country. That's a country.
Okay. And that's the,
These are you only fill this out if you're claiming tax treaty benefits. You don't want to fill that out. You're not claiming any of that.
Okay.
So you don't fill out 2.
Three is not applicable.
You don't fill this out either.
Okay, certification. You just sign it, upper and lowercase.
And the capacity, you put national of the United States.
Right.
I don't know if I can get all this in here.
Has to be pretty small. Okay.
That's it. Sign it in red ink. And sign it just like you got it up here. Jean-Blaine, family of Keating. You sign it down here. When you sign it that this is the way it is here. This is the surname. That's what the king, that's how the king used the last name, that's the surname. That's how the people became slaves of the crown. This is my name, Jean Blaine. I went into court and told the judge, he says, "Are you Gene Keating?" And I said, "I'm Jean Blaine, family of Keating." He says, "You don't have standing to come into this court."
I told him I was Maria Janet. I was known as Maria Janet. And
what did he say? What did he say?
About 4 times. He says, "Well, I'm going to use my commercial charter on the paper." And I said, "Well, I conditionally accept your offer to do that upon proof of claim that I am not known as Maria Janet, and you will address me as Maria Janet." He said, "Well, fine. I'll address you as Maria Janet."
Good for you. You're a woman after my heart.
I haven't used that commercial charter in about 8 years. I don't even know what it is half the time.
Okay, does everybody know how to fill this out? Now remember, this is different from the other W8BENs.
That's why we've been taking screenshots, Gene, so that they know the difference. This is the one that's for non-resident alien. Okay, let's go back to the 709 form.
Okay, so you fill this out first before you fill out the 709.
Now, do you send that one in first before you do the 709?
Yes.
And you wait for it to come back, or how long do you wait?
Well, you can send them in together.
Oh, you can send them in together. Okay.
This is how you fill it out. You put your donor here.
That's
donor.
Capital letter names. And so
put the all capital letter name here.
And then your address in the corporate style. 1234 State Street. The legal residence would be address would be the number 1234. Legal residence would be State Street, right?
Yes.
And then city, state, and zip. It's amazing how they always put the state now in lowercase. What would be the citizenship?
That means that the state is a foreign country when you spell it like that. When you spell it with a capital S, it's the corporation. It's the corporate state.
Right. So what goes in line set in box 7? National of the United States?
Well, you put I'd put C.
W8BEN? Okay.
So you can put this, actually I'd do it this way.
Okay.
If the donor died during the year, check here and enter the date of the death.
They didn't die.
Enter the total number of donees listed on Schedule A. Count only, okay, the donees are the servicing company. Now here's your Schedule A.
Okay.
Put your item number these. Donee's name and address. That would be the lender.
Lender first?
Yeah.
Okay.
Okay, then you put description of gift. If the gift was of securities, give CUSIP number. The gift was of securities. You gave them a security.
Okay, so you have to have a CUSIP number.
Yeah, and you get the CUSIP number. Okay, watch. Okay, these are your there's your, over here is your registration numbers. See these numbers over here?
Yeah.
Those are your registration numbers.
And you have to look up the prospectus to get those, right?
Yeah, you have to look up this is on Bank of America.
Okay, so what if you don't have Bank of America?
Well, you find out who the entity is.
That would be the mortgage company.
Okay, can you read that? What does that say right there?
Read what? What am I reading? Point. No, I can't read that. QSIP number 040506CQ7.
There's your CUSIP number.
And that's for Bank of America.
Yeah, that's the CUSIP number.
Okay.
It's 060505
CQ7.
CG7.
G7.
Charlie Gertrude 7.
Oh, not a Q, a G.
That's a G.
Okay.
CG7.
Okay.
I don't think I can blow this up any bigger.
No, but you stated it, so that's good.
This is where you find your CUSIP numbers. You got to go down through the form. They list the CUSIP numbers in here.
Right.
In the form.
In the prospectus.
Yes.
And that's usually under the table of contents?
Yes. So you go up here. See, this is the name of the REMIC. This is the REMIC right here. It says
Where?
BAC right here.
I don't know where.
BAC, Bank of America
Capital
Corporation
Trust.
is what that means.
Yeah, Capital Trust.
This is a company.
Yeah.
It's a Delaware company. It's registered in Delaware.
Right. My company was listed as a Conseco Securitization Trust. This one is Bank of America Capital Trust
13. That's your REMIC. That's the taxpayer that has to pay the taxes.
Okay.
Okay, here's your, if you go into your table of contents, see here, it tells you, like for instance, it tells you who's who in here. Usually lists the,
I used to always go in the table of contents and look for the word trust. And it always gave us the section where the trust was identified. That's been a number of years ago, though.
It's, okay, here's the trust.
And it goes, the prospectus usually states right in it that the lender sells all right, title, and interest to
That's the purchase agreement. That's in the purchase agreement.
Right.
They make that between the issuing, usually the issuer, the servicing company is the depositor, and they sell the loan documents to the trust, which is BAC Capital Trust 13, or the trust. It's a statutory trust organized under Delaware law pursuant to a declaration of trust. They do a declaration of trust or a trust indenture. And they appoint an indenture trustee. A lot of them use the Bank of New York. They get their nose in all this stuff. That's Cain and his descendants. Back here it is. The trustees will be the Bank of New York as the property trustee or property trustee. As the Delaware trustee or Delaware trustee, and 3 individual trustees are regular trustees, which are either employees or officials or affiliated with us. Remember, these people, the trustee is the one that's liable for all the taxable terminations. Okay?
All right, let's go back to the 709 form.
This is another place you can get CUSIP numbers. See where it says CUSIP number?
Yeah. That's on Info Pro.
This tells you
Zimmerman.
CUSIP numbers.
Zimmerman.
This Committee on Uniform Securities Identifications processes.
And what's this site here? Zimmerman's?
If you want to wait for up to 2 weeks, you can order a CUSIP lookup from CUSIP Global Services for just a few dollars. It tells you how to do it. Send an email to CUSIP corp at CUSIP.com. Send an email. On the subject of the email, indicate CUSIP number lookup. Attention, Rosalinda. State your request. Reference the issuer name, issuer description, maturity, rate, and any additional information. In fact, here's the telephone number, 212-438-6565. To pay by credit card, and you will get an email with your result.
Read that number one more time.
212-438-6565. Everybody got that?
I think so. We stated it, so it'll be on the recording.
That's how you get your CUSIP number, or you can look it up on the B5 prospectus.
Let's go back to the 709 form.
So you got the Okay, this is where we left off.
Right.
The donee is the servicing company or the lender. Donee's adjusted basis of gift. The date of the gift would be closing.
What is the adjusted basis
Of the gift?
Yeah.
Is adjusted basis of the gift is capital transfer.
Which is the amount of the mortgage.
Right. Value at the date of the gift is the amount of the mortgage. For split gifts, enter half of column F.
Okay, what's the split gift?
Well, value at the date of gift. You only list, in other words, I guess if you split, I'm not sure what that means, whether they're talking about.
Would that be a
Well, it means, it explains here, complete only if you are splitting gifts with your spouse.
Oh.
I mean, he or she. In other words, he gives half and she gives half.
Oh, okay. The net transfer would be subtract G from F.
Yeah.
Oh. But if you're not splitting it, then you don't put anything in, then the net transfer would be
You
what?
don't fill this out if it's not a split.
Right,
If
it
it's
would
only
be just,
he, she, gift, and you don't fill that out.
oh, okay. All right.
Don't fill that out.
Okay.
So you go down here to part 2. Direct skips. Gifts that are direct skips are subject to both. Remember, what is a direct skip? See, you guys don't know how to fill these out because you're not reading.
Okay, that would be a direct skip would be from you to the servicing company.
No, what did it say in 2612? What did it say a direct skip
Was it a trust or it was a human natural person?
Yeah, that's in 2613.
Right. But we don't have direct skips, do we? On a mortgage? You do or you don't?
Yes, you do.
So we have to fill out part 2. Do we not fill out part 1?
Where are you at? We're in part 2.
Yeah.
You put the donee's name and address. Relationship to donor, if any. Relationship would be donee. Description of gift. If it was a gift of securities, give the CUSIP number. You gifted securities.
Okay.
So you put your CUSIP number down here. Put securities.
Okay, what would C be?
2632B, election out. Well, let's go look at that, see what that says. 2632. 2632B.
Yeah. Okay.
Okay, here's what a direct skip is. Read what that is.
It means a transfer subject to a tax imposed by Chapter 11 or 12 on an interest in property to a skip person.
Okay, what was a skip person? Remember, it's a natural person or a trust.
Right.
So if you transfer property to a trust, it's a direct skip.
Okay.
And it's subject to a tax imposed by Chapter 11 or 12.
Okay.
This is a Chapter 13 tax.
But on the form it said 2032.
Allocation, read that. That's
Any allocation by an individual of his GST exemption under Section 2631 may be made at any time on or before the date prescribed for filing the estate tax return for such individual's estate, determined with regard to extensions, regardless of whether such a return is required to be filed.
Well, so you have that means generation skipping transfer. That's what this is dealing with. You're doing a generation skipping transfer.
Okay.
So you have to these are special rules. So you have a generation skipping transfer exemption. Made at any time, go ahead and read that.
Where? May be made at any time on or before the date prescribed for filing the estate tax return.
So you have an exemption. And this tells you, 2631 tells you what the exemption is. Go ahead and read it.
For purposes determining inclusion ratio, every individual shall be allowed a generation skipping tax exemption amount which may be allocated by such individual or his executor to any property with respect to which such individual is the tax transferor.
That's the donor.
That's us.
Yeah, you can give them the exemption if you want.
We can give it to them?
Well, isn't that what that says? Shall be allowed for purposes of determining the individual ratio, every individual shall be allowed a generation skipping transfer exemption amount which may be allocated by such an individual or his executor. You can allocate the exemption.
You would be dumb if you did.
Well, that's not the point. The point is that you can do it if you want to. If you don't want to, but, well, maybe that's what they're doing. Did you ever stop to think of that? Maybe they're assuming that you're allocating an exemption to them so they don't pay the tax, they make you pay it.
Yeah.
Remember, if they use it, you can't use it.
Yeah.
And the donor's liable for the tax.
Or if we use it, they can't.
Right. Now you're starting to understand.
Okay.
I knew you were a smart cookie. Okay, so does this answer your question in regard to 2632?
Well, we want to know how to fill it in on the form, Jane.
Okay, let's go back down here. I think this is the form is here, I think.
I know we'd all like to stay till a long time. We're going over time right now. It makes the file very big to transfer, so we have to be careful about that.
Well,
we have to finish this form real quick.
Okay, well, you got your 26-3-20 election out, which is 2632B.
Okay, so that means that, what do you put in that square? Nothing?
Okay, here, read this. Here's 2632B.
Deemed allocation to certain lifetime direct skips. Any individual makes a direct skip during his lifetime. Any unused portion of such individual's exemption shall be allocated to the property transferred to the extent necessary to make the inclusion ratio for such property 0. If the amount of direct skip exceeds such unused portion, The entire unused portion shall be allocated to the property transferred. Boy, you got to put that in English.
Well, it means that if you want any unused portion of your exemption, the donor's exemption, remember, you're the donor, shall be allocated to the property. In other words, you can allocate it to the property necessary to make the inclusion ratio for such property 0. So
Okay.
what that means is that the tax on the property goes to 0. There's no tax.
Right. If you use your exemption.
If you use your exemption.
Which
if
we
you
also
include it, or if you allocate it. If you allocate it to the donee, then he doesn't have to pay any tax. You got all this power and you're not using it. They're making you pay all the taxes, and the people, my people perish for lack of knowledge. Because they have rejected knowledge, I have rejected them.
Yeah, it looks like this form is going to take some more business next week, Gene. We got to devote most of the hour next week to this form and the 706 form so that people don't get in trouble when they try to do this.
Okay.
Because we're almost a half an hour over class time right now.
Okay.
So where do we stand? I know a lot of people have been waiting a long time to do this. I have one more question before we go tonight. That question is, how do you undo a ward of the court when the person is being held on a mental holding that the judge has and the judge has refused any kind of representation to such individual?
Does he have an attorney?
No, they're not giving this gal an attorney, and they won't get her representation. She's being held like a political prisoner.
What is she being held for?
Just a mental thing. They wanted these people's property for whatever reason, and they came in and took the house and took the car and stuffed her in a mental institution and not letting her out, not letting her have counsel, not letting her have anything. Took the husband to task and, went after him. All kinds of stuff. So they're trying to undo this war.
Where is this at?
Oregon.
Is this the case they were telling me about?
Yeah. They're trying to get this gal out of the noose hold. They won't even give her representation or attorney or anything.
Are you talking about the judge?
No, the poor girl that's being held. The judge won't let her have an attorney or anything.
Okay, who's the judge?
Oh, man, I don't know the direct name. I can get it for you later.
Get me the judge's name.
Okay, I'll talk to you about that tomorrow some more then.
All right.
Okay, with that being said, we are at the two and a half hours on the class tonight. This next week we will come back in on the 706, 709 form. Jane, you will get me an example of your security agreement and the power of appointment format that you used. And that should be included in the attachments for this week.
Okay.
Oh, no. Okay, with that being said, I just broke something. We are very thankful for all of you people that are on the line. I love you lots, and I know Jane does. And as we work through all these forms of what we need to do, I just want to say thank you to everybody. Closing comments, Jane.
I love you, dear memories. I forgive you, dear memories. I'm grateful to you, dear memories. I thank you, dear memories, and I'm sorry for you, dear memories. Clean. I love you all.
We'll see you again next week.
Thank you so much, and we're going to stop the recording. Thank you.